India is obsessed with laws. We have laws that range from prescribing fines for jumping traffic lights all the way to those aimed at social justice in the form of guaranteed food and work rights. If this worked, India would be the proverbial Sone ki chiriya. But the reality is different. A naive belief strongly held by the Indian intellectuals of the 20th century is that laws will solve every problem. But most don't seem to recognize that deep-rooted structural changes cannot be brought about by proliferation of laws. Now, there's no denying the fact that society becomes chaotic in the absence of laws. Laws are in fact essential to the well-being of any civilized society. They are there to facilitate a smooth functioning of social transactions. But very often, a law created to deal with one set of social problems creates entirely new set of problems. The case in point is that of the uses and abuses of the anti-dowry law in India. Dowry is a payment made in cash or kind to a bride at the time of her marriage. Before modern Hindu law came into place, women usually did not have equality in inheritance. So dowry was seen as a gesture of goodwill towards the soon-to-be married daughter. As Veena Talwar Oldenburg pointed out in her scholarly book Dowry Murder, The Imperial Origins of a Cultural Crime, dowry was an integral part of Stridhan, the six-fold property of a woman over which she had entire control from the time Manusmriti was compiled until the arrival of even the British. With the arrival of colonial modernity, it no longer remained an article of the appreciation bestowed on the daughter by the immediate family and by extended kin and friends. The safety net devised to protect the married daughter in times of crisis now suffocated her. Some families of grooms would demand extra after the wedding, and often the bride's family would budge under this pressure and make the arrangements. Because resisting such demands could put their daughter's well-being at risk of harassment, including physical assaults and mental torture, sometimes resulting in the woman committing suicide. How did the Indian state decide to deal with this problem? In 1961, the Dowry Prohibition Act was enacted, but it seemed to be not doing enough to prevent dowry deaths and harassment of brides in their matrimonial homes. So, India introduced a tough anti-dowry law, Section 498A of the Indian Penal Code in 1983. The nature of section is such that it mandates such complaints to be registered as cognizable, non-bailable, and non-compoundable offences. A cognizable offence means that the police officer can arrest the person against whom a complaint is made under this section without a warrant. Non-bailable implies that the arrested person cannot be given bail without a court's ruling. This also means that until the time court schedules a hearing, the arrested person remains in jail. A non-compoundable offence means that the person who made a complaint cannot withdraw it. In majority of these cases, the complaining woman leaves the husband whether charges are true or false. In other words, fathers are separated from kids, from their old parents and other family members without any investigation, no questions asked. Until 2014, 498A led to immediate arrest of husband and his family members as soon as a complaint was filed. Lakhs of men and women have been arrested under this section in the last 3 decades, despite being totally innocent. The misuse of this section is such that in 2005, Supreme Court called misuse of IPC 498A legal terrorism. In 2014, the Supreme Court observed the fact that Section 498A is a cognizable and non-bailable offence has lent it a dubious place of pride amongst the provisions that are used as weapons rather than shield by disgruntled wives. In the case of Arnesh Kumar versus State of Bihar, Supreme Court passed guidelines to contain arbitrary arrests under 498A. Despite that, Lakhs continue to be arrested under this section till date. In 2020 itself, with almost half the year under lockdown, 1.2 lakh people were arrested, of which 96,000 were men and 23,000 were women. When there is a law, there is a loophole. Lawyers use legal loopholes to encourage their women clients to falsely charge their in-laws with 498A and also slap multiple other laws. A complicated case with lots of sections usually translate to a larger sum of money that can be extracted from the man and his family. This means more legal fees for lawyers. The nexus of police and lawyers is nefarious in this regard. Police trumps up the charges so that they and the lawyers can make their wallets fatter at the cost of a family. These cases tend to be long drawn and pocket draining, almost like a quicksand for the accused. The more they struggle, the deeper they sink. Allow me to make you a little more uncomfortable. According to the National Crime Record Bureau statistics, the conviction rate of cases under 498A has drastically reduced from 21.9% in 2006 to 13% in 2018. The conviction rate of 498A cases in 2018 is almost a quarter of the conviction rate of all IPC crimes. Data indicates that while the highest number of FIRs are filed under Section 498A, the conviction rate is one of the lowest. While there are enough provisions in the law to punish instances of domestic violence and harassment of married women, sadly, there is no law in India that gives a man protection from marital abuse and domestic violence. The only way a man can get some peace of mind is by filing for a divorce on grounds of cruelty or in extreme cases by committing suicide. And there has been a lot of suicides. Even then, he does not get any respite from legal torture. Law is meant to formalize societal norms, but laws like 498A actively undermine the most important unit of social order, the institution of the family. Law alone can never solve the problems of society, which can be tackled only by a strong sense of community. What we need in India is a revival of customary justice mechanisms and strengthening of community values to reduce the instances of abuse from happening in the first place. 498A misuse has to stop, and if not, this law needs to go. More spousal murders occur in the US to collect insurance money than what's called dowry murders in India. Guess which country makes special laws? This is Deepika Narayan Bhardwaj for Upward.